So this next panel discussion is updates from the courts. We have with us today representation from the Ontario Court of Justice, the Ontario Superior Court of Justice, and the Ontario Court of Appeal. I will allow our panelists to introduce themselves briefly, and then we'll move on to some questions that I'll be asking. Start right here.
So, Alex and I'm Lainey Bassman, and we're sharing the role of Rosemarie today because she's unfortunately unable to attend today. So I'm Senior Family Counsel at the Office of the Chief Justice of the Superior Court of Justice of Ontario.
And I'm Alexandra Spinelli. I'm the new Acting Modernization Coordinator for the Superior Court of Justice.
Hi, I'm Kathleen Murphy. I'm the Executive Legal Officer for the Ontario Court of Justice in the Office of the Chief Justice.
And my name is My name is Jacob Bakan. I'm Special Counsel of the Chief Justice of Ontario at the Court of Appeal for Ontario. Now working with newly appointed, not so newly at this point, but relatively newly appointed Chief Justice Tom.
Is everyone hearing okay?
I can't hear you guys very well.
Can you hear me now? Oh, the mic wasn't
Is this
on.
better?
Hi, I'm Kathleen Murphy.
There you go.
All right. Do we need to redo Jacob's introduction?
Do you want me to introduce myself? My name is Jacob Bakan, and I'm Special Counsel to the Chief Justice of Ontario at the Court of Appeal for Ontario.
Thank you. Thank you for reintroducing yourself. We appreciate that. So question number one to our panel. Can you please tell us about significant changes in the courts over the last 2 to 3 years? In whatever order you'd like to go, and if you could make sure everyone gets an opportunity.
Sure. I think perhaps we'll have some similar things to say, and it would be the similar experience that we've all had in the last 2 to 3 years, which was the most significant shift for the courts was the impact of going completely virtual, essentially overnight or after a very short amount of time, which demanded incredible stretching from the bar, from the bench, from court staff, and really from everybody involved in the system. And though for years we've had a number of different projects trying to make certain things digital, and there are certain things that are digital, there's still a very long way to go in the justice system. And so it's almost entirely a paper-based system that overnight had to conduct itself in a different way. So I would say that that was the biggest impact. And in that time, there was increasing video, which was always a part of the agenda, but it made it happen faster. But in some circumstances, it was Band-Aid. And so some of the things we have to do now is take off the Band-Aids and put in more permanent solutions, and really invigorate some of the projects we'd already had underway to make things digital and really get those going in deeper earnest. But there was a lot of Band-Aids during this time too, because you can't just take that system and make it go like that in a day, sadly.
Yeah, I mean, what was the best of times was the worst of times. So, I mean, the pandemic was horrible, and it was also allowed for incredible innovation and cooperation. I want to say that, you know, I've worked in the Office of the Chief Justice for 10 years. I've never seen such cooperation with the judiciary, the bar, and the government of Ontario. It was really remarkable. And from the bar's perspective, FOLA was right there, and was, you know, Katie was working with us, and it was really helpful for communication and for figuring out best practices to have organizations like FOLA participating and really proactively participating, coming up with, you know, protocols and suggestions, and, you know, almost immediately I was getting calls saying, what can we do to help? And it was really a remarkable time, and the bar was really excellent throughout. It was, you know, the Court of Appeal was already on sort of the track towards innovation. We were configuring a product called C-Track, which is the Thomson Reuters product that we're still working on configuring, but it's transforming our case management system, and It will have a fancy portal for e-filing and e-payment. That's not there yet, but all of a sudden, like, everything got supercharged, and we needed to do things right away. So for us, we didn't use case lines, we just used email. We're still using email. That's our e-filing system. We went all electronic pretty quickly. We were using a product called Court Call. I don't know if any of you remember that. It was an American product that was going to be a video conferencing all-in-one solution. It just wasn't doing what we needed it to do, and we quickly switched to Zoom. And again, that was because the bar was saying, "We're using this. This works." So we all switched to Zoom, and it was just a truly dramatic change. The former Chief Justice Strathy, was a big advocate for modernization, and he used to give these talks where he would said if my grandfather was a time traveler and showed up in today's society, he would be completely amazed at all the technological transformations going on in society. He couldn't believe all this electronic stuff, all this computers, all this transportation, blah, 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 blah. And then he would walk into the Court of Appeal. I'd invite him to come see a case, and he would be there, and he would say, "Nothing looks like it's changed." And then just rapidly, there was a whole lot of change in cooperation. I think it sort of shows what can be done, and what we can continue to do.
And just to kind of supplement all of the good points Jacob and Kathleen have made for their courts on behalf of the SCJ, similarly, we also had to pivot quite quickly in the path of COVID to kind of move us away from the paper-based filing and kind of introduce more innovative and technology-driven things just to deal with, health and safety of the public. And, there was that little piece where SCJ kind of had to move some operations while we worked on getting something in place to actually be able to support hearings during the pandemic while protecting everyone's health and safety. So just some concrete examples of the work that the SCJ has done over the past couple years with the pandemic. So, for example, electronic filing. Prior to that, you'd have to go into the counter. We really kind of moved quite quickly with kind of COVID shutting everything down to electronic filing from email. And then, of course, worked quite quickly with the Ministry of the Attorney General to come up with the Justice Services online portal for civil and family filings. And as a result of kind of that early work that we did at the beginning of that point, we were able to kind of advocate to expand JSO so that it can accept more filings, and cutting down on time in the counter. And of course, as FOLA is well aware, we did host the ministry hosted some town halls, in which the courts was also there to kind of get the feedback from the bar about what services JSO would need to have in order to really work on that expanded filing. Just to Jacob's point about the virtual hearings, so obviously we had to quite quickly. The OB did help us out by providing us with Zoom lines at the beginning of the pandemic so we could support virtual hearings across all regions, because prior to that, it was only in select regions that needed that capability. So ultimately, the ministry ended up procuring Zoom for us, and it's still, as you all know, in use today to kind of support that. Also, as a result, as we had the hearing platform, we had filing in place. Our court also kind of spearheaded the procurement of case lines by advocating with the ministry, and that was just so that way documents could be accessed in this kind of new virtual world, so everyone had access to the same documents, as you all know. And we are continuing to work on the case lines front with the vendor in order to, after getting feedback from FOLA, kind of enhancements that we can, just that would make it a better kind of functioning platform. We also had to move in other directions, never mind just the hearing. So for example, for scheduling, we wanted to cut down on the time that it was taking for counsel to get dates for certain matters where you'd have to go back and forth emailing scheduling staff to get those dates. So we implemented Calendly, and we're still kind of working with it in pilot phases to kind of potentially expand it for more civil matters and more family matters. That will allow, it's basically a reservation kind of system. Some of you in some of your regions may already be familiar with it, where you can go in and request a date with the court, or at least see when the court is available without having to engage in the back and forth with scheduling staff. And of course, that all kind of culminated into this desire and this advocacy in MAG, where the SCJ spearheaded the initiative for a kind of court digital transformation project that really highlighted also our collaborative working relationship with the OCJ, so that we can kind of have this comprehensive solution that will involve all those band-aid solutions that we had to spearhead for the pandemic.
Just one last point, because most of these changes that are named were all in the tech sphere, and that was where all the action was at. I wasn't at the office. I recently joined the office in November after most of the chaotic, apparently endless meetings and flurry of activity took place. But I know that in that period, and you're well aware, that the SCJ introduced the presumptive guidelines for the modes of appearance in civil, family, criminal, divisional, and small claims. And so it's been piloted, I suppose, in our province, and as you all know, is up for assessment.
Thank you. We'll move on to the next question then. The Ontario Court of Justice recently updated their website. Are you able to tell us some key points or the thoughts behind that update?
So our new website, which was launched on Monday, I don't know if you've had a chance to look at it. I hope that it's doing what it was meant to do, which was take a very user-centered approach. Our websites, I don't know how many of you have been involved in doing a website, but it is a thankless, terrible project. And sadly, this was my second one that I got to be involved in, and I never want to do it again after my first. But you learn lessons, and with this website, we're really trying to make it user-centered. What are the most, when people go on, what are they looking for, and how can we get them to what they're looking for quickly? We did do user testing and focus groups, and I'm hoping that our website is working for people, but it is something that needs to constantly evolve. So if you do have feedback, we're genuinely interested in how to make it better. So please do, you can let Katie know, and Katie can pass it on to us, because we really want to make information easy to find. This includes user guides for unrepresented litigants as well, or for anybody who's going through the process to try to help them, and ensuring that the lists are posted and all of that.
Thank you. So this next question is directed at the other panelists, really. Is there anything that the Superior Court of Justice or the Court of Appeal are working on that you'd like to share with us?
Sure. One minor but important thing. The Court of Appeal, we were the last court to still have capacity limits. I don't know if any of you appear in the Court of Appeal, but we were still limiting capacity. We are still limiting capacity to parties plus 2 people. So we're catching up with the rest of the world, and just right after the long weekend, we are lifting those capacity limits. So all members of the public and the media and anyone else who wants to come can come, as long as you can fit in a Osgoode Hall courtroom. We're not getting rid of our video access, so that's going to continue. So people can continue to write in and say, I want to watch something, and can watch it by video. So unless it's in camera, of course, or there's some other reason why it shouldn't be on video, but the presumption is that it's available. We recognize that the out-of-court experience for remote counsel is not always that great. Currently, in a lot of our courtrooms, you have 2 sort of wide-angle cameras, one facing the judges, one facing the gallery and counsel. So with the Ministry of the Attorney General, working on a project which is going to have a much better view for people watching remotely, where you will see each courtroom participant in their own window. So it will allow, in instances where there is somewhat of a hybrid experience, it will be better. A couple of courtrooms already are sort of halfway there, but it's sort of been put together with duct tape, and it's going to be, it will be, hopefully by the end of the year, it'll be much better. Another thing, as I mentioned, C-Track is, which is our case management system. We are bringing online this year the public-facing portion of that. So there'll be a public filing portal, a fee payment portal, and it will also allow parties to access documents through the portal. Finally, we are converting one of the Osgoode courtrooms to a fully accessible courtroom, which we think will have the best accessibility standards of any courtroom currently in Ontario, and hopefully will become a model for other courtrooms. But every participant judges, the parties, people watching will all have adjustable desks. There'll be all kinds of audio enhancements. Things are going to be movable. We've been asking for this for a long time. We're very happy that it's going to be there, and we're really quite pleased that this will finally be done. We've been asked for about 10 years.
So from the SCJ perspective, during COVID, as you're probably well aware, there was a scramble to update notices and notices to the profession in order to catch up with all of the changes that were taking place. A consolidated notice to the profession was released during COVID to try to capture the main lines of that, but the feedback we've received is that there's still a lot of clicking around in order to capture the information that is needed to appear across the province. So we're in the midst of a consolidation exercise, archiving outdated material from our practice direction, integrating the notice to the profession into a one-stop shop depending on your area of practice so that you have one place to go, connecting to the regional practice directions or notices. And so that's been sort of a big exercise at our office to make things easier for people navigating those directions. And we're in the process now of also revising our guides and information for unrepresented litigants in the court system, so trying to continue to offer a plain language resource for people to be able to access the information they need. So we're maybe doing it from the other end because we want to get that good information in place first before we do what I think is a well-needed update to our website.
Just to kind of go off on Lainey's on CJ having recently updated their website. After we get kind of all that in place, we're going to actually, because again, it's not very user-friendly, I think we can all say that. We've been doing a couple of little things in the interim. For example, we kind of created recently a case lines tab because the case lines information for the SCJ was all over different areas of the website, so at least we were trying to consolidate the kind of relevant current information into the one place. And that's just kind of the start of, again, as Lainey mentioned, this more kind of comprehensive website update so that it is more user-friendly. You can easily access information. Stuff isn't buried kind of in all the different areas. Then just on kind of the other kind of technology stuff we're working on, I mentioned the kind of courts digital transformation, how that's a comprehensive solution. That's where a lot of our focus is because we know that at the end of the day, that's going to end up being a huge potential resource to kind of really streamline the process of digitization. And I just also want to talk about other work that we're doing on the more kind of hardware and like physical side of things. Obviously, with all the kind of digitization that we had to do, the actual physical courthouses and physical courtrooms also need to be able to support hybrid hearings, which means the inclusion of technology into that. So our court is advocating quite strongly with the ministry, as I know the OCJ is as well, in order to get kind of better equipment in the physical courtrooms across the province in every region, including kind of better Wi-Fi, so that, because again, if we have all of these different things, even when we get that kind of big end solution or something that's going to be more comprehensive, the issue is like if we have all that and that's great, but if you can't use it in the courtroom, what's really the point if you can only do it on your office or if you're zooming in? So again, we're really working quite hard with the ministry and in collaboration with the OCJ to get that equipment in the courtrooms, and that's kind of where a lot of our focus has been, so that we can increase the kind of technology capabilities of these areas.
And just on the heels of that, there is, the presumptive, the guidelines were released last March, I think, and we had promised that these would be a living document and would be reviewed in the year following. So the bar and after the bar and the court had some time to work with them. So in February, we released some questions for feedback. We've received this feedback as of April and are reviewing it. By and large, the results have been overwhelmingly positive. We're digesting it. We're going to make some decisions, and we'll be letting you know fairly soon what the next stage might look like. But there has been, it seems, a very positive reaction to the balance that was attempted to be struck between convenience and efficacy, and the benefits of actually being in a physical room to deal in particular with the conferencing and other stages of the court process.
Thank you. We'll move on to our next question, which I know is very important to a lot of people in this room. Can you explain consistencies or lack thereof in our courts?
Well, the chuckling of the audience makes me think that this is in fact one of the most important questions. So it's an interesting world, the justice system, in that there is a constant attempt at balancing the need for consistency and same across the province, and also recognizing that the local need and the way things work. And of course, the most obvious example is what might work for a fly-in court in a remote community is completely different than what might work for Toronto. That's the most stark example. But you could even have different cultures of the bench, the bar, and within a similar sized place, a similarly proximate place, that might have different cultures that where some things work in one place and then they don't really work as well in the other place. As the court, and we would all have our own answers to this, as a court, we really are striving to try to get as much consistency as we can while recognizing that what works in Toronto may not work in a First Nation fly-in community. And so, as an example of that, for motive proceedings, when we were meeting with people to talk about virtual versus in-person and meeting with the bar, including some representatives from FOLA, the main thing we heard from people was they don't want to go back. They don't want to lose the gains that were made during COVID, and we agree. They want to know what the situation is going to be. They want some certainty. We agree. They want some flexibility as well. We agree. But it's very hard to make a policy that does all those things, gives you certainty and flexibility, and but that's what we're trying for, is to give enough certainty that you can with some flexibility built into the system. It's difficult. And I think it's just, you can't have it be exactly the same everywhere, but you can have certainty and predictability in your practice for the most part. So we are striving for that. I'd be interested to hear too, maybe afterwards, Katie, you can share with us some of the particular issues that you have, because I can tell that this is definitely one that's generating interest from the audience.
Yeah, I mean, I think we follow the same broad strokes. It's hard to get into all of the examples, but there is that balance of exactly, as was mentioned, local practice, culture, expectations, and what works somewhere and why upset that, versus consistency and predictability, and so that there's a message for the bar and for the public about how to access the court system. I can say that certainly when it comes to what I've seen so far, the technological solutions and direction is really an emphasis on trying to have consistency. But, for example, the example of modes of proceeding, it may not be able to look the same across the province for all sorts of valuable reasons. So it's a broad strokes answer. It's probably not that satisfying, but again, willing to engage if there's specific issues you want to talk about.
One thing, too, that I think is important to note is we're in this weird interim time, and so there are lots of things that we want to do. I know the SCJ, the OCJ, the Court of Appeal, we're all advocating for certain things. We're advocating very hard to have really good hybrid equipment in every single courtroom. So if I have an in-person hearing planned and the lawyer has COVID or something else, is sick but not too sick, like they can potentially participate virtually, that we would, or a witness, or an expert witness, if he's coming from far away, that would be able to do something in person, but also type in a witness. That, I think, is something that we for sure all want. It makes sense, but not every courtroom can do it. And so there's a reality to our scheduling where you actually have many courtrooms, and an acceptable, in my view, amount of courtrooms that do not have the equipment to be able to do what we want to do. We want to be able to bring in a judge from far away and clerks from far away to help a court that's suffering in a day with too many matters on their docket. We want to be able to do that. We don't have the ability to do it right now. And so we're waiting. We're kind of working to that long-term vision of that court digital transformation when we actually have an end-to-end case management system where you can, from the filing to the disposition stage, that's going to change everything. And then I think we're going to be able to achieve so much more. And the good news is we're working on that. But in this weird time, we can't do what we necessarily want to do as a whole system, I think. And so we have to kind of just keep pushing to get to that next stage where we're able to achieve way more.
A little bit, speaking about the hybrid equipment in the courtrooms. Everything else that was mentioned, obviously, in terms of like the inconsistencies in the process, but sometimes you kind of lose sight of the fact that the physical space of each individual courtroom within each individual courthouse is different. And that sounds like an absolutely insane thing. I'm like, well, why would that impact consistency? But as Kathleen mentioned, in this weird interim stage where we're trying to figure out how to outfit each of these courtrooms to be able to deal with that flexibility of, this particular matter, we might need to kind of like have a witness appear virtually. In this particular matter, maybe there's multiple people. Perhaps there's an accused person who's in custody and we want them to be able to appear virtually for whatever reason. So this interim phase where we're trying to figure out how it kind of all works is potentially where we have a lot of those inconsistencies, and it's for a whole host of reasons, some of which process and some of which that just have to do with physical makeups of each of the region and the physical makeup of the kind of courthouses.
Thank you. Any other comments?
Well, to say the Court of Appeal, we're consistent across the province. Everyone has to, everyone coming to a hearing at Osgoode Hall has to go through Toronto traffic. I mean, we are, again, I hope across the province the fact that we've had a flexible approach is helping. I can't imagine that it doesn't help us, particularly for motions, that people don't have to come to Toronto for every Court of Appeal motion, and all our single judge motions are virtual. And at least for the time being, we have a completely flexible process. If for any reason, we ask people to tell us if they're going to come in person or if they're going to come remotely. If for any reason up to the last minute they have to change that, they can change it up to the last minute. Everyone will have a Zoom link. And so for the time being, we have that sort of maximum flexibility. I mean, maybe in the long run, maybe everyone's going to start saying, no, we should be demanding that everyone come in person again. Right now, we're not. So.
Thank you. So we spoke earlier about significant changes over the last 2 to 3 years. But we'd like to look forward now, and what can we expect in the next 2 to 3 years?
So, I mean, for us, I mentioned that we're in the next year launching a new portal. We'll be looking for your feedback on that. I think that as a new Chief Justice, obviously, he's very interested in how the courts can do a better job of communicating with the public, communicating with the bar. So we're going to be doing a lot of, work on that in the coming years. I think we're all dealing with issues of sort of widespread, quickly spreading misinformation about things. I think it's a dilemma for everyone, for the bar, for the judiciary, how we explain to the public what we do, how we avoid misinformation about the whole, what all of us do. You'll likely be seeing, years ago, we used to do outreach visits to different communities. Likely be seeing a return to doing some of those visits for the Court of Appeal. Go into different regions and meet with the bar and the local bench, and if there's a law school present, the law school and maybe some community organizations. So we're considering that and working on that, and you'll likely be doing another round of those. We sort of did every region of the province at one point, and then sort of took a break. I think those things, and as we've all mentioned, enhanced AV equipment to be doing virtual and hybrid hearings better. We're likely continue with. I think it's been very valuable for the public to be able to watch proceedings remotely. It's often very important for Northern Indigenous communities to be able to watch. Once we had a hearing where we actually rebroadcasted through a local cable network, would be open to doing that. If there is a sort of a small community where there's perhaps an Indigenous community where there's not everyone has good Wi-Fi or whatever, and the easier way for people to watch a hearing that's of great importance to that community would be through through if they have some kind of closed circuit network in the community. We have done that before, and there's no reason I think we couldn't do that for particular communities where it's important and can be worked out fairly easily.
On the tail end of that, I mean, we talked about a couple of the things that we're working on presently, but there are some big questions that the court, like all of us, have to think about in terms of what it means to access, or what the open court means in the digital world, what the court file means in the digital world, what evidence looks like in the digital world. You know, we're on the cusp of some, maybe everybody thinks they're on the cusp of some massive transformation, but I really feel like we're on the cusp of a massive transformation. So those are sort of more longer reaching questions that we're forced to think about right now. And obviously it's going to be in conversation with the bar.
And I think just kind of on that, right, the main thrust of this is the digitization that we've kind of all done, and all of these kind of initiatives, it's not going away. So it's just a matter of how do we take all of the band-aids that we had to do over COVID and make something that's actually comprehensive, that's more streamlined, that actually works. We know with the SCJ the frustration of having to file in one platform and then having to upload after the fact. I know OCJ does as well for their family, where they're using case lines. So it's just about how do we streamline these processes so that it actually, in the 2 to 3 years, in the longer term, everything is a little bit more easily accessible, and we've kind of considered all of these questions. And again, feedback from the bar is important because it tells us what's working, what's not working, what do we have to do to kind of fix it and make it better.
I think that's right, and I don't think I have too much to add to it. Like I said, some of the main things that we're working on already, but another emphasis for our office at least is and I think across the board, is judicial education and ensuring that the bench have the appropriate or a good level of education and cultural competency and indigenous and matters and across the whole spectrum, and so we're very committed to that, and across a whole lot of other things. So we're always continually trying to refine our education, make it stronger and better.
All right, thank you. Last question. Can we talk about backlog and what the courts are doing to address backlog?
You want to go first?
Backlog. It is a very serious problem, for sure, in the criminal courts right now. I don't know how many people here are criminal practitioners versus, and I actually don't know the backlog that exists in the civil world, and if it's at the same level of crisis, but in criminal, certainly, it's real. The issues are real, and we are trying to increase the number of judicial pre-trials and increase the number of having every case that's over a certain amount of time going from a regular case management court into a judge-led case management court, where we're trying to ensure that the case is actually is moving forward in a meaningful way rather than churning. So we have a problem in that we have too many cases in the system, and we also have cases that seem to just keep spinning in the system, and so we need to attack that problem from both sides. And we're definitely seized with the issue and daily trying to effect change. But it's a real problem right now. In that there are more cases than what the system can handle. We don't have enough resources. I hope that this is not. There's no media in the audience, right? Is there? But I don't think it's a secret. There aren't enough resources to handle the cases that are in the system. That's the truth. And so but please don't quote me to the media if that's okay. I consider this a safe space.
We're just going to let the panel finish answering that difficult question about backlog, and then we'll open it up to the floor for questions.
So I can pick up from the SCJ perspective. You know, we have to prioritize in scheduling our criminal law cases, our Hague abduction cases on our UFC sites, our child protection cases, given the constitutional and statutory time limits for these cases. So sometimes matters like civil matters get backlogged a lot more significantly. So there's going to be a first ever civil law strike force 100% virtual civil trial sitting for the Southwest region, cases for 4 weeks in November and December 2023. And the second virtual civil trial sitting is planned for April 2024, so this is hopefully going to reduce the backlog. In the family world, in collaboration with the OCJ, the Family Law Rules Committee has made some changes to the rules to make every court attendance meaningful, including requiring parties to confer in advance, to allow case management, to allow a judge to set out the appropriate procedure for a motion to change, the early exchange of financial information. So really making efforts to try to make these cases meaningful. Innovations like binding JDR, judicial dispute resolution in certain family cases was piloted in the province. It's a more streamlined way to have matters finalized without the need for a trial through, in theory, same-day hearing in front of a judge who can help to settle some of the issues, and for those issues that can't be resolved, make final decisions on any outstanding cases. So it's an innovation in our courts that seems to be proving very successful in reducing court times and reducing trial dates and settling matters. So we're hoping to expand that if possible and in other centers in the province, and there have been family case conference blitzes in Toronto and Brampton. So efforts are being made to try to tackle things where they're most needed, but again, it's an ongoing
Well, at the Court of Appeal, we're in a fortunate position of not having a backlog. That's not to brag. It's just that it's when the number of trials were reduced during the pandemic, it means that you're actually lowering the flow of appeal. So we didn't have the same challenges. So now that the trial courts are catching up, my anticipation is that if there are all these blitzes, then we're going to get it later. So we might have some delayed problems, but at the time, for the time being, we're okay. I mean, if the number of appeals do spike, it's going to be very difficult, particularly if we don't start seeing some appointments. Anyways, but we have 3 vacancies right now, so obviously that's a stress. But.
And one thing on the resource question is that during the part of COVID, and I think it's still happening, I don't know about you all, but in my household, people are sick on a continuous loop. I have 3 kids, and somebody's sick at all times with something different. And the court staff are no exception to that. And so they have been genuinely probably a 30% reduced workforce, which makes it very hard to mount. So on any given day, you might have to close trial courts, or the administrative judiciary are making decisions looking at the whole master picture. What are we going to close down today? And it's not through anybody's fault. It's not through anybody's fault. It's just the reality of what's going on that is making it very, 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 very challenging. And then in certain places, the lists are so long because it's backlog that people are sitting really late, and people can't do that either. And so then people are quitting because their job is overly onerous and for clerks. So it's tough, and it's tough.
Thank you. So we're going to open up the floor for questions. There's 2 microphones set up. If you don't mind approaching the microphone if you have a question, just stating your name and your law association.
Hello, I'm Edward Kiernan, the president of the Norfolk Law Association. And we've heard a lot of almost exclusively comments about technology.
Can you speak closer to the mic?
I'm sorry, yes. So I'm Edward Kiernan from the Norfolk Law Association, and we've heard comments from the panel almost exclusively about technology, and I had some questions about people. In our CPD sessions, we hear a lot of comments from panels of judges about problems with things the bar do that annoy them. Things like lack of civility, etiquette in the courtroom, and lack of professionalism and lack of competence, which leaves the judges carrying a heavier burden, having to do the heavy lifting and writing a decision and things like this. They don't get good facta and things like that. And I'm wondering if you're in a position to comment, since you work every day with judges, on give us a temperature of the judges in terms of, are they happy with the bar now? Or is there a lot of white-knuckle, tooth-grinding, eye-rolling despair?
They're always happy with the bar in a general way. I think, you know, I don't know what the percentage is, right? It's not a big percentage, but there is a percentage of lawyers who have done things like appear from bed shirtless. So those are the things that don't help. It's part of when we're talking about remote proceedings, one of the things that the judges are saying is that it does appear that people are taking the matters as seriously. This is for the clients accused, as well as for some lawyers. It's not helping things when people do that, but I'm sure there's none of the people in here who have done that, and there are a number of lawyers who, of course, are treating those remote proceedings with the utmost seriousness and respect, and as though they were in in-person court. So we're still hearing things that are happening, but I do think I'm hearing those things less. I don't know about other people, but I'm hearing fewer of those kinds of stories and more that I think things are leveling out a bit.
But I have heard the concern raised about mentorship opportunities in the new way the court operates, because obviously those decorum issues or the competence issues are shared from mentor to younger calls, and we really are in a stage where it's probably not as easy to make those connections and to just observe a court proceeding, learn the ropes. So certainly that would be welcome if there were other innovations for mentorship. Mm-hmm.
Question?
Hi, I'm Riley Johannesson from Parry Sound, and that means that I'm from Parry Sound and Sundridge, which is a satellite court in the Sundridge arena, and so I'm very sensitive to the issues about consistency across the province and how things are working locally. And so I understand that, and I don't want to go too far with this question, but very concerned about the MAG staffing issues. And is anybody on the panel in a position to speak to whether there's some kind of plan in place to address this? Like in Parry Sound, we just lost our last court reporter.
Yeah.
We have I think 2 court staff on the ground, but there are other people who come in from elsewhere and they are helping. It's terrifying as a lawyer standing in court every day. I'm doing my work and things aren't being recorded and written down.
Yeah.
And so I realize that that's a MAG issue and it's going to need to be worked on. But where does this all fit in together? Is there a plan to address that? The actual people who are doing the work?
Yes.
Thank you.
We share that, and we are continually advocating for the same. One thing that MAG did recently was they're kind of complicated, but there are a number of positions that are part-time or contract positions where people don't get benefits, they don't have guaranteed work, they don't get paid for certain things. They've just converted a number of those part-time contract positions into full-time positions, which is actually a pretty big step because it means that those people will get benefits, they'll get vacation. It's a much more secure job, and with that, they also got a raise, a salary increase. So they moved up into the next category of in their band. So that I understand is MAG's first step. They're heavily recruiting. They're looking first to the inside people who want those positions to be able to interview for those positions. And we're hoping that can be a difference and that can truly make a real difference in people's lives for being able to stay in this work. I think that they're probably thinking about what next, what beyond that, because I'm not sure that it's going to be the total panacea, but at least it's a step. It's one of the first things we've seen in a while that can potentially make a difference. Now we just need to be not having court go so late so that people can stay. But there's, that should take, it's going to take a couple months to get there, but hopefully it will produce results.
This is the last question.
I feel like I'm putting my head on the block here a bit, so bear with me. One thing I've noticed, and this goes back to the consistency issue that we've all been dancing around, is I do a lot of litigation in fairly geographically separate courts, and one thing I've noticed is that the bench isn't unified about how they want materials presented to them, sometimes even in the same courthouse, where I have appeared before judges who they're not interested in paper, they're not interested in the email you sent. If it's not on case lines, it doesn't exist. And I could probably say I've had judges who may never have opened their case lines account and demand before your appearance the big stack of paper with the base numbering and all of that jazz. Is that one of the issues that is going to at some point be resolved, hopefully in favor of digital, or are we going to be living with that for a while?
Just before you leave the mic, could you state your name and your law association for us, please?
I'm not sure I want to, but Mark Ducharme from
I'm going to take a picture while you do that. That's okay.
to our panel.
I have a question. Are you mainly in the OCJ, the SCJ, or are you in both courts?
I'm in both courts. The problem so far has mostly been in SCJ because I haven't done a lot of files with case lines in the OCJ yet. It's still kind of coming in.
So I can kind of take it.
Yeah.
I think a lot of that, like, we have kind of heard that, and it is something that we are actively working on with, engaging with the bench, and we've heard all the feedback from the bar on it. I think a huge reason why that is happening is a lot of it is because of people Band-Aid kind of interim solution fit. We know that there are gaps with case lines. Again, we've heard feedback from the bar on it. We know that there are parts of it that are kind of more labor intensive. That's why that we have, and with Meg and with the OCJ as well, we engage with the vendor and we provided that feedback so that they can actually improve the functionality of the system. It's lived some of it, and I know that some of the hesitancy is particularly for example, civil matters. They tend to be more kind of document heavy. Their documents are a lot of pages long. If the system's lagging and you're sitting in court, or like when the judge was preparing to review it beforehand and the document was lagging, that's obviously, they don't use it, and then they tell you not to use it in court. If it's a judge who is very comfortable with the technology and they use it that way, or if the particular case doesn't have a lot of documents, so the system loads and it all works wonderfully, then that's great. So I think a lot of it is in terms of personal experience using the technology. We are working actively right now with the vendor to address some of those gaps, particularly in terms of load times, ability to upload, hyperlinking, all of that kind of stuff, again, based all on the feedback that we've received from the bar. So I am hopeful that we will start to hear less of it. There was a lot more of it. What I will say is there was a lot more of it at the beginning when we first implemented case lines with the SCJ. I've heard a little bit less of it now, so at least I'm hoping that, judiciary are more comfortable with it on that level, but we are aware that it's still happening. We are working actively to address at least the technology gaps of the platform so that way, if it's functioning the way that it should, there is no reason that, you should still be using paper and that kind of thing. So we are working on it, I promise.
Thank you. So to our panel, thank you for being here today. We really appreciate your time.